I'm Gary Brimley. I am the regional engineer for the Weber River and West Desert Region Office, and I've worked with the Division of Water Rights since 2008. So my assignment is to tell you everything there is to know about forfeiture, non-use, and rebuttable presumption of quantity impairment. Not your everyday advanced water right topics. Rebuttable presumption of quantity impairment. If you get familiar enough with that, you might start calling it RPQI. So here we go. In this presentation, we already mentioned forfeiture, non-use, which includes non-use applications. So we'll talk a little bit about what they are and what they mean, and rebuttable presumption of quantity impairment due to non-use, the long form name, if RPQI wasn't already long enough. So forfeiture is a fundamental concept of the prior appropriation doctrine here in the state. The definition of forfeiture comes from section 73-1-4 of the Utah Code. Some people know it as the use it or lose it rule, or the use it or lose it law. What it means is a water right has to be exercised. It has to be placed to use on a pretty well continual basis. And if it gets set aside, the water user ceases to use it for 7 years, 7 consecutive years, then it's subject to forfeiture. And there's a key phrase there, subject to forfeiture. Forfeiture is actually a judicial proceeding. So it's not a passive thing. It doesn't just happen. So forfeiture, your water right is not just automatically forfeited if you cease to use it for 7 years. It's not automatic. So, and it's not declared by the state engineer, because the state engineer is not part of the judiciary. So it has to be declared by a judge. So it's a judicial proceeding. It's not an administrative action. And an action in court must be filed within 15 years of the end of the latest period of non-use of 7 years. So if you have a water right that you've been using for 1 year and then not using it for 5 years, and then use it for 1 year, and then not use it for 5 years, and then 1 year, is that water right subject to forfeiture? It's not subject to forfeiture. If you have a water right that you didn't use from 2000 to 2010, and here we are in 2023, is your water right subject to forfeiture? It is. I see the right signal happening over here. So 2010 completed within 15 years of today, and so that water right is still a potential candidate for a forfeiture action at court. You go file at court and get a judge to declare it forfeited. If it's forfeited, the water right reverts to the public, which means that the water in the general hydrologic system is available in priority and is available to appropriate. But it's not a specific target. A person doesn't come to the state engineer and say, okay, that guy just forfeited his water right, I want to appropriate it. You don't appropriate that water right that got forfeited. Instead, all the water rights in the hydrologic system shift down in priority. If you excise a water right from a priority schedule, then all the junior water rights now are satisfied to a fuller extent, to the extent that the water right that got forfeited lost some water. Also, there's this little bullet point that says plus any approved non-use periods, and what that means is that a non-use period, and we'll talk about non-use applications in just a sec here, a non-use period is not part of the period of analysis used to determine if the 15 years, so an approved non-use period, and let's review it in a second. I'll get to that. If a water right is forfeited, our database status might have one of three designators. It might say terminated, it might say forfeited, because it does. We have a status in the database that says terminated, a status that says forfeited, and a status that says disallowed. There's not a lot of difference between those. There's a little bit of difference between disallowed on some files and forfeited, and I might have to clarify that. So disallowed is a status that comes from the adjudication action, and we'll talk about that on the next slide. So an aggrieved party can file a lawsuit, which would be someone that is expecting to use water from that same source, an adjacent water user. Or the state engineer may file the lawsuit, but this would be typically in the course of a general adjudication. So in adjudication, there's that status, that database status, disallowed. We will investigate claims. We'll investigate all the water rights in a hydrologic watershed. And when we investigate all the water rights, if they are not in use, or if a water right is not in use, we will designate it to be disallowed. That's our recommendation to the court. We go recommend to the judge that the water right be disallowed, and at the end of the adjudication proceeding, the judge issues a decree, and that water right gets forfeited. So it's the same result as forfeiture if we designate a water right as disallowed during an adjudication proceeding. As soon as the state engineer recommends it to be disallowed, then that water right is no longer a candidate for administrative action, even if the judge hasn't signed off on the decree yet. So the state engineer will decline to process a change if the state engineer's recommendation remains disallowed. A decree will bar claims of forfeiture during the past, claims of forfeiture for prior non-use of rights determined to be valid. So rights determined to be valid in the decree. If the adjudication goes forward and the decree gets issued by the judge on the entire adjudication, and the judge says all the rights in this list are valid, then any rights in that valid list, you can't look back. There's no look back period on those rights on the good list. There's no look back period. A decree bars claims of forfeiture for prior non-use for rights determined to be valid in the decree. Yes? After a decree, yes. After a decree, if a 7-year period of non-use arises, a 7-year period when the water right owner fails to exercise their right, then that right can be subject to forfeiture for that period following the decree, but no periods prior to the decree. So a new decree does not excuse future use, future beneficial use requirement on the water right. A water right will always have to be beneficially used to maintain it, and that is just integral to the use it or lose it law. Okay, so we'll have to talk about what a non-use application is. We'll get to that in 2 slides. Right here, exceptions to non-use or exceptions to the forfeiture law. If you have an approved non-use application, which means the state engineer, which means you, the water right owner, have applied to the state engineer for an excuse to the beneficial use requirement that says, I plan on not using my water right for a period, usually 7 years. And the state engineer reads your non-use application, advertises it, finds that there's a justification for that non-use, and approves that non-use application. Okay, moving on. A lease, so a water right subject to a lease agreement or a government fallowing program or insufficient water, which is to say if your source has not been producing the water for your use, then your water right is not subject to forfeiture. You simply would have used the water if it were available. And so the forfeiture and non-use law is more of an accountability and kind of a reportability, kind of a relationship, an active relationship with your water right and your and the state engineer's office, maybe, meaning you're there, you're present, you're aware, you're taking care of your water right, you're using it. That's what this forfeiture and non-use concept is all about, is you're participating, you're active, you haven't set your water right aside and moved on. That's what the forfeiture and non-use concept is all about, is being active, being a participant in your hydrologic system and using your water right, or being engaged with our office. If you're not going to use your water right, you're reporting to our office, you're filing a non-use application, or you are responsive. You would be using your water right if there was enough water. And priority cuts, which is essentially very similar to the above bullet point, insufficient water. If there's insufficient water, a priority cut is called. You cannot use water from the source because in priority you're not entitled to that water because senior water users are entitled to it. Also continued, water storage projects, surface or groundwater recharge, or if substantially all of the water right was placed to use, meaning you have been using your water, just haven't had all the water available, or it's been used at its place of use from its point of diversion. A public water supplier is also immune to forfeiture if the target water right or the water right at issue was acquired by the public water supplier prior to May 5, 2008. So any water rights a public water supplier held since any date before that is not a candidate for forfeiture, is not subject to forfeiture, period. And if it was acquired after May 5, 2008, the public water supplier is supposed to seek and obtain a change application approval from the state engineer. And if they do, then that water right is not a candidate or a target or subject to forfeiture. Also, supplemental water rights. Yesterday you had a presentation on supplemental water rights. You have a right from a stream and a right from a well was the example that I heard in the presentation. And they're not using the right from the well at this time because the right from the stream is providing enough water, adequate water. And the right from the stream doesn't dry up in July and August, and you don't need your supplemental well. Now I'm changing the scenario. And for 7 years, that stream provides adequate water and you don't use your well. That well water right is not subject to forfeiture because you are exercising your water right. Your water right is a supplemental use group. Your right is a right to irrigate that field, and you are doing that. So your well water right is not subject to forfeiture. Or if you're diligently pursuing a change application, so you've set your water usage aside, you're no longer going to grow crops because you're working on a development to build a big subdivision, and you've obtained a change application, and you're building that development, and the water's not in use. And it takes you a long time to build those homes or that apartment complex, and it's getting delayed at all angles, and your water's not in use, but you're diligently pursuing that change. Any change. So the change application or the nature of the change does not matter as long as the change application is pursued diligently, as long as the change is approved and keeps in good standing, even with extension requests. As long as the state engineer approves extension requests, the state engineer will approve extension requests if you're diligently pursuing the change. And so that being the case, that water right is not subject to forfeiture. So what is a non-use application? Finally, I get to tell you. So a non-use application, you apply to the state engineer and you express your desire to set your water right aside for a time. You have any good reason. You're going to be out of the country for a length, or you have other plans that justify not using a water right. And there's actually a list in statute of potential reasons, and the last reason on our non-use forms says any other good reason that justifies non-use. So in statute it says a non-use application shall be granted if the applicant provides a justification for non-use. It protects the water right from forfeiture. So there's a couple of words on here. It says protects from non-use. It protects it from forfeiture during the period from filing to expiration. So it does not protect it if it's already subject to forfeiture. So you have a water right that you didn't use from 2000 to 2010, and now it's 2023, and you haven't had a non-use application on it, and now you file a non-use application. That non-use application today doesn't protect the water right for that period from 2000 to 2010. And a non-use application does not constitute beneficial use, and that's an important point, because say you have a non-use application on your water right. So there's a new different scenario. Non-use application approved starting in 2000. The water right was good. It was good all the way up till 2000. You've been exercising it till 2000. Then you file a non-use application and it expires maybe in 2005. And then you don't use the water for 3 years till 2008. And then you file another non-use and it's good till 2015. And then you let that application expire and you go for 5 more years till 2020. And then you file a non-use. So there was 3 years of not using the water and 5 years of not using the water and an in-between time of not using the water covered by a non-use application. There's 8 consecutive years of non-use, and that water right could be subject to forfeiture. So the non-use application does not constitute beneficial use, and it basically what it does is it exempts that period of time from the analysis. In fact, it exempts that period of time from the analysis that includes the 15-year look-back period. I'm going to go back a slide to the 15-year mention. It exempts the water right. So a non-use application exempts the period of time from the analysis. So if you're analyzing whether a water right is subject to forfeiture and there's been a non-use application involved, you just don't look at that period of time and you look back beyond that non-use application. You can't include the non-use period in your 15-year period. You could theoretically end up looking back a long time. What happens if the property exchanges hands? It does not protect the new property owner. The water right is what is being reviewed and analyzed, and ownership is not part of that. What was the question over here? How do you prove non-use, and conversely, how do you prove use? Okay, so all the evidence is brought to the table. There may be records of diversion and use. There may be records of a crop produced or of expenditures to, on the farm. There may be records of sales of product, which is an indirect way of demonstrating water has been in use. How do you prove that it hasn't been used? You may be able to look at aerial imagery and see the fields are never green for a series of consecutive aerial imagery from different years. So there may be testimony from neighbors. I've never seen that field be irrigated. I haven't seen that field irrigated for 20 years. So how do you prove that it's been used? You might have testimony from your neighbors. Oh yeah, I remember when that field was irrigated from about 2012 to 2018. So it's just bring the evidence to the table and evidence for both sides. Go ahead.
Excuse me, what about shares in a irrigation company that have a water component to them? Are those subject to forfeiture?
Yes, okay. So what about shares in an irrigation company? Are shares subject to forfeiture? The answer is yes. Shares can be subject to forfeiture. All or a portion of a water right can be subject to forfeiture, including shares held by shareholders in a company. They can be subject to forfeiture. All right. Yes, sir.
Just a little bit of clarification on last.
Yes, go ahead and take the mic from behind you.
Give the mic. Just to kind of expound on what Gary referenced, the shares themselves are not subject to forfeiture. The underlying rights are. However, the company can then turn around and reallocate shares based on whoever caused that forfeiture. So the shares are your interest in a company. The state engineer or the courts aren't going to forfeit those, but they will potentially forfeit the underlying rights, and then the company can go back and say, hey, you're the cause of this forfeiture action, so we're going to adjust your shares accordingly. So I just want to provide that little bit of clarification.
Thank you. Go ahead.
If that's the case, can you apply for a non-use of a share?
Yes, okay. So he says, if that's the case, can you apply for a non-use protection on a share? And the answer is right here on the last bullet point on this slide. So a non-use application may be filed on all or a portion of the right by, and the third bullet point is a shareholder. So on the water represented by the stock owned, after that shareholder gives written notice to the company, that shareholder can file a non-use application on that share, which is to say a non-use application on that portion of the company water right represented by his share. Or a non-use application can be filed by an appropriator or the appropriator's successor in interest. And then this middle bullet point is not who can file, but it says an application does not constitute beneficial use. And I think we already went over that. So the state engineer shall grant a non-use application if the applicant shows a reasonable cause for non-use. In other words, justification. So the statute actually lists several reasonable causes for non-use, which specifically include a bunch of talking points here. Demonstrable financial hardship, physical causes that render use beyond reasonable control. Go ahead, Eric.
We have a question in the chat.
Yes, please.
It says, hi Gary, Nasia here. If a farmer wants to claim the drought as a reason why they are not using their water in an area that there is an open and active adjudication, do they need to file a non-use on their water right to properly document this reduction to their water usage and protect it from forfeiture?
I'll take a stab at the answer, and I'll let the people in the back support me. I think that it would be a good idea to file it because there's not a direct fallowing program in place. There's not a direct demonstration of the reduction in water, and so I think the best idea would be to file a non-use application. I'll see if Mike from our adjudication section has any input.
Yeah, so there's certainly no reason you couldn't. You certainly could file a non-use application. However, once the adjudication's underway, that filing of a non-use application doesn't go backwards, I guess is what I'm trying to say. So if water hasn't been used, then that we still might evaluate that. Now, I think the question was regarding drought. If you remember, drought or unavailability of water is one of the exceptions to non-use. And so, all those things have to be factored in. It can get very, very complicated in evaluating it. I guess I wouldn't look at non-use applications as this silver bullet that would get you out of trouble or get you out of a problem you're in. But if you have an anticipated period of non-use, then certainly it can be used for that purpose.
I think it's worth adding that the scenario is always reviewed on a case-by-case basis. So widespread drought is not a widespread reason for all the water rights not to be exercised in a geographic area.
We have another question in the chat.
Go ahead.
Lori asks, is there a max period of time or years that you are allowed to file a non-use application?
Okay, is there a maximum period of time or years? No, there's not. Each non-use application it covers a period from when it's filed to when it is expired. And if you need to file another non-use application and you have adequate justification for it, then you file another non-use application and the state engineer approves it if it's justified. And if you file non-use upon non-use, a string of non-use applications, that may happen and does. Go ahead.
Does the canal or irrigation company need to sign a non-use application?
Good question. Does the
What if adverse review having that water climate right?
That's interesting questions. Does the canal company or a share issuing company have to sign, and can they refuse? And what happens? So the answer, I think, is yes. The canal company or the irrigation company has to agree to your application. And what if they refuse? If they refuse, then that's probably an action between you and your company. I'm going to look to the back we're seeing some nodding heads from our applications and records assistant state engineer. Not to the company's advantage to refuse, though. Don't see why they would refuse. Okay, thank you. Good questions coming up. Very good. So let's see. In the interest of time, I'm going to skip reading you these bullet points. I think you have them on your handout. So we're going to move on to quantity impairment. Rebuttable presumption of quantity impairment and the two-word term, quantity impairment. So now I have to split some hairs. So a quantity impairment, the two-word term, is a reduction in the amount of water available to an existing right if a change application is to be approved. So if a person files a change, gets a change, and that takes water away from another water right holder, that's a quantity impairment against the other water right holder. Okay? And so a quantity impairment reflects a diminished quantity of water, which could be a change in the timing of the water received by the impaired water right, or it can be an enlargement of the quantity depleted by the person receiving a change, which reduces water available to another water right. So that's what a quantity impairment is. And now we're going to go to rebuttable presumption. In a change application proceeding, an applicant bears the burden of producing evidence the change can be made, including that the change will not cause a specific right to experience quantity impairment, and rebutting the presumption of quantity impairment. So I have to tell you now what is a presumption of quantity impairment. So there's two things going on here. There's A and B going on here. A quantity impairment is a standard approval criteria for all change applications. a change cannot be made that moves a water right to a place where it will take someone else's water. That's just a quantity impairment to the prior right in place at that location. B, a rebuttable presumption of quantity impairment due to non-use. RPQI is an issue that is raised due to non-use of a water right. So I'm going to get into it. So RPQI is how the state engineer can consider non-use during the change application process. Meaning, if the state engineer finds that the water has not been in use, and this is actually quoting from the statute, there's a rebuttable presumption of quantity impairment to the extent that for a period of at least 7 consecutive years, a portion of the right identified in a change application has not been diverted from the approved point of diversion and beneficially used at the approved place of use. In other words, if you've not been using your water right, exercising it, like we've been discussing the non-use issue, then the state engineer may raise the rebuttable presumption of quantity impairment, or an applicant may raise it. Go ahead and jump in.
Sorry, so I think the slide needs to be updated. There's been a little bit of a statutory revision. So instead of an and between those two elements of rebuttable presumption of quantity impairment, it's an or, meaning that either one of those, if either one of those conditions is the case, then that condition exists. They don't both have to exist for the condition to exist.
Can you run through an example?
We'll get to it. We'll get to it. So if you haven't been using the water like you should, the presumption of quantity impairment may apply. We'll get to what, so we'll get to an example. So who can raise it? The state engineer can raise it, or a protestant may raise it in a timely protest. Okay? The state engineer or the protestant must identify a water right that will experience quantity impairment, presumably the protestant's water right, if in the case of a protestant, or presumably a junior water right in the case of the state engineer identifying this as an issue. So we will send a letter to the applicant, and we may hold a hearing. I'm just going to go see if I have any additional on this notes here. Okay, we'll get to an example. Let me get to the example. I really want to okay, in a few minutes we'll get to the example. So how do you rebut? Generally, the presumption of quantity impairment is raised when you haven't been using the water right, or when, you know, the evidence in front of us, the evidence in front of the state engineer is that you haven't been using the water right, and so the rebuttable presumption of quantity impairment is raised. So to rebut it, you demonstrate how the water right has been in use, or how the water right has been protected from non-use, from forfeiture due to a non-use application, or any of the other excuses in the forfeiture statute, the unavailability of water, the government fallowing program, etc. Those excuses that were listed. So the rebuttable presumption does not apply if it's excused by the exceptions in the statute. That's the red line. Or if you have, you know, including these items, an approved non-use application, or an in-stream flow application, or the passage of time, right? If the period of non-use being identified is beyond the statute of limitations, if it's 30 years ago, then it's not an issue. So that is also sometimes referred to as the Lazarus Clause. You resurrect your water right by placing it to use for 15 years. Okay. I'm not going to go through in-stream flow to a great extent. In-stream flows are applications that you can file a change on and gain a state engineer approval to allow your water right to stay in the stream, which means you're not going to take it out of the stream and use it for your fields, right, or for your other uses. So that's the extent of in-stream flow that I'm going to go into. It's a change application, you get an approval, you leave your water in the stream. Does quantity impairment only come into account on a forfeiture? Yes, so this rebuttable presumption of quantity impairment issue is only raised in the context of this non-use for 7 consecutive years. So yes, that's what we're talking about. Thank you. That's right. This is the administrative. You may think of this as you may think of this as an administrative equivalence in some way. Okay, so it's an administrative equivalence of forfeiture. It's not a forfeiture. You do not get a declaration of forfeiture on your water right through this. If this happens, if rebuttable presumption of quantity impairment is raised on a change application, it just puts that water right back to the file. The Lazarus clause can still apply. You can continue using the water at the place for the purpose that it currently has. So let's clarify that a rebuttable presumption of quantity impairment issue is only raised in a change proceeding, a change application. Let's make sure that that's clear. So only if a change is being filed asking to take the water to a new place from a new point, something like that, new purpose of use, then rebuttable presumption can be raised if the water right hasn't been in use. Okay, so the exceptions to non-use, a lease, a fallowing program, I'll read them this time: insufficient water, priority cuts, water storage, substantial use, public water supplier, supplemental water right, and diligently pursuing a change application. We went through all of those in the forfeiture section of this presentation. So I'm going to get to the example you asked for. It's coming up. So sometimes when rebuttable presumption issue is raised, the person says, but I've been leasing the water. Just down the road, the neighbor's been using it. He's been taking my water. He's been putting it on his ground, and my water right shouldn't be subject to this. And in order for that to be true, we need written documentation, and that use by that neighbor needs to be terminated in order to obtain the change application, unless the change application is to move the water right to that neighbor's use. The public water supplier we already went to. The water right has been acquired before May 2008. Then it's protected from forfeiture and the rebuttable presumption of quantity impairment. But if not, the issue may be raised on a change application by a public water supplier. So the issue can be raised on any water right that has not been in use and that is subject to these provisions, these considerations. Here we go. Here comes the example. So the farmer files a change application on a water right with an 1890 priority date. The historical place of use has been a Walmart parking lot for 10 years. A protest has been submitted alleging quantity impairment due to non-use, and the protestant's water right is junior. Has rebuttable presumption of quantity impairment been raised? Yes. Yes, it has. Also, basic quantity impairment could be an issue. You know, a change application, any change application, regardless of the non-use and the use it or lose it considerations, if the water right, 1890 water right's a good water right, and the 1910 water right's a good water right, and the change application wants to come take water from the source from the 1910 water right, basic quantity impairment's an issue. Okay. The farmer now has a 1940 priority date, and the protestant's water right is 1910. Otherwise, all the other things are the same. Has the rebuttable presumption of quantity impairment been raised in this case? Protestant's water right is a senior water right now. So it changes because the quantity impairment, the rebuttable presumption of quantity impairment issue is only applicable where the water rights system or the distribution in priority is a consideration that is a factor in the consideration. Protestant's water right is not presumed to be impaired by the change application because he can just call for the water to come to him in priority and have Farmer Bob's water right turned off because it's a junior water right. Yes, Blake.
I think you may have misspoke when you said that the rebuttable presumption of quantity impairment is not a factor here. That can be raised regardless of priority dates based on non-use. I think what you were meaning to say is just the straight quantity impairment,
Okay.
right?
Perhaps.
Non-use is if there's a non-use issue and they raise quantity impairment, the presumption of quantity impairment exists.
Okay. Very good. I don't, I, this is a complex, let's go back to slide number 2. This is a not your everyday water right advanced
So let me
topics.
use a microphone this time, okay? And so the presumption of quantity impairment relates back to non-use. If a water right has been subject to non-use for a period of 7 years, the presumption that it will impair existing rights exists if it's raised. Now, quantity impairment is related to whether it will actually impair a water right based on the reduction in the amount of water available and those types of things. So priority is more of a function in that. But raising the presumption of quantity impairment, the rebuttable presumption of quantity impairment, can be raised if it is just based on non-use.
That's what Blake says.
Did I misinterpret what you were saying, Gary?
I've probably got a bit more to learn on this topic.
Okay.
This is not your everyday advanced water rights topics. Can we move on? A change application is filed on a water right in 2021. An approved non-use application was filed in 2015. It is clear and obvious, though, so part of the scenario, it's clear and obvious the water right has not been used for more than 7 years prior to 2015. So, can someone raise rebuttable presumption of quantity impairment? Yes. Okay, so things to consider. Let's say someone files a change application today on a water right appurtenant to land that is now a big box store built in 1996. The big box store may own the water right. First off, they may be the owner. Better check the deeds. A person can verify if a non-use application has been filed by checking the records of the state engineer. That's a very straightforward thing to do. If it's been filed, it'll be on our records. It's been more than 7 years. That's pretty obvious. The state engineer may raise the flag of rebuttable presumption of quantity impairment. And so if we do, don't ignore it. The applicant bears the burden of rebutting the presumption. Bears the burden of demonstrating why this change should be allowed and that the water right is not subject to forfeiture, right? So is non-use excused? Things to consider, right? Consider what you can do up front, what you can do in the filing of your change application. You can consider providing additional information at the time of filing before the application gets advertised in the legals. Before the state engineer reviews your application, on the day you submit, you can make your case. You can explain your issue and you can prepare a heretofore map showing what will be retired. And that's all I have. Do we have questions? Yes, please.
So on a big box, they obviously can't do anything for that point of diversion that's underneath their store because it's all impervious surface. But could they Lazarus loophole that by leasing it to somebody for 15 years?
That's a great question. So on a big box store, can they Lazarus loophole that water right and resurrect it by leasing it for 15 years? This exception where it says leases and written documentation is required, and this other provision that had the and or in statute. We're going to get to that just in 2 slides. This diverted from the approved point of diversion and used at the approved place of use. There's a little bit of conflicting hurdles. Your scenario that you ask if you can resurrect that water right by placing it back to use is going to run up against this provision in statute. Potentially can run up against this provision in statute where it says the water right has to have been diverted from the approved point of diversion or beneficially used at the approved place of use. The and or in this statute, and I think if it hasn't been both of these, if one of these fails, then it fails because of the or provision. You know, if it's one of these, then it fails. So all right, we're beyond that.
Gary,
so.
I just Dave did it again. Asked a great question. That's way too advanced for this presentation. I mean, we could run hypotheticals again. I think Dave, I could spend time with you and we would have a good time. But ultimately, they have to file a change application on that water right? And if the big box store had been there for 10 years and they leased that water right out to somebody else, then they were like, okay, let's make that a permanent. So they file a change application. Now we come and say, okay, when did that lease start? Did that lease start after the 7-year period or before? And we take that into consideration, and then we would, I mean, obviously the state engineer would raise the rebuttable presumption of quantity impairment because there's not use at the historical place, and then we would evaluate the evidence that they submit to us, and then we would act on that change application before us. And in this scenario that you're talking about, I don't believe that we would approve that change application because the lease started after that period of non-use. And so they can't rebut that presumption because the lease doesn't excuse that period of non-use that occurred prior to the lease starting.
Bottom line is, if you've understood most of this stuff, it's commendable because this is advanced stuff. Go ahead, Ryan. How would you lease water that's under a building? That's the point, right? So the point of diversion, if the source were under the building, you can't use it. If the place of use is under a building and a parking lot, you can't use it at the place of use. So that's a direct answer to the hypothetical, right? You can't bring it back to life. Please. Okay, basics. Let's hear it. Okay, a general approach to why would someone pursue a forfeiture action? So there's I wouldn't say maybe very few, but there are not a lot of private forfeiture actions that have happened that I'm aware of, but there are some that I am aware of, and sometimes neighbors have been at odds with each other, even family against themselves, right? Family against family, cousins. And they will file an action that ropes in the issue of the validity of the water right or the usage status, the exercise of the water right. And the action is broader than forfeiture, but forfeiture is one claim among 10 filed at court, and the judge, in that proceeding, in addition to whatever other thing the cousins had against the cousins, the judge also says, by the way, the water right's forfeited, based on the evidence and the claim made in the case, in the proceeding. Nathan. We'll get a microphone.
we have critical management areas that are overdrafted, and so when somebody wants to put a water right back into use, even if it's at the historical point of diversion or place of use, it could cause somebody else to be bumped off the priority schedule because we have to work back to a safe yield date. And so that's actually a case where I think it makes sense to bring a forfeiture action, because you let them back in, you do yourself harm.
And so the consideration can be very broad. It can be a whole geographic area where the resource is shared, like the groundwater aquifer. It's a shared resource between thousands of people, and any one of those is affected if the water right is brought back to life.
We have an online question.
Go ahead.
This was submitted a few minutes ago, so we might have shifted topics, but they said, is there an advanced class for this stuff and more?
No. You can certainly discuss it with the state engineer's representatives. We'll be happy to have greater conversations at length. Go ahead. Here comes the mic.
So as a public water supplier, if there's private wells, say in your public water supply district, and that are no longer in use, but they still have those rights to those wells, but they're not being used, and you file a forfeiture on those, can any of those rights be obtained, I guess, from the public water supplier in any way?
So,
or the priority dates, I guess. I mean, priority dates are dropped in ours.
so if those water rights have been forfeited or have not been in use either, if those rights have been forfeited or have not been in use, it is not likely that the state engineer will approve any change applications on those specific water rights, and the appropriations are in priority, in the line of priority. So if you're intending to reappropriate by filing an application to appropriate, your priority date will be, now. You don't acquire those water rights and get their priority. So I don't know if I'm necessarily...
As a public water supplier, we're supplying the water because they're not using the well, so we are supplying the water.
Okay, so as a public water supplier, if you're supplying water to a single property, they used to have a well, they used to use a well, it was a domestic use and a small lawn and garden, and now they've ceased using their water from their well and they've hooked up to your system and their water right is not in use and hasn't been, it's the likeliest thing is that their water right is no longer a good water right.
I think the bottom line is once a water right is forfeited, it's dead, right? You don't resurrect its priority date. You don't acquire the priority date. It just goes away, as Gary has said, in the distributions by priority. And so any new application would have a junior priority date.
And so the one thing that can be added to that is the owner of the little well that hasn't been in use can't succeed on an argument that, well, I've been using water, it's been coming to me from the public water supplier, so my water right's still valid. They probably wouldn't succeed on that argument.
Yeah. Well, I think we're getting a bit far afield. Why don't we move on and we can have a private conversation about public water supplier and the nuances of forfeiture if you'd like later.
Any last questions? Okay.
And I do want to retract my earlier comment. Gary was correct. It was a very nuanced example, and I failed to pick up on the nuance with regard to the priority date and the raising of rebuttable presumption of quantity impairment. So what Gary did say is accurate. It's probably a little bit too nuanced for maybe this venue. Obviously I got caught up in it. So if you have questions about rebuttable presumption of quantity impairment, which is very complex, trust me, we work on it every day, and we have different opinions about it. Please reach out to a regional representative or myself, and we can have a longer discussion. Don't worry about it. If you don't know what the problem was, then you're good to go.
Oh, we had someone ask if you could repeat scenario 1A again.
Let's have you Scenario 1A was the one where the
I think that's the one where I got caught up in wrapped
If-
around the axles. Let's not repeat that scenario. I think that's a scenario that needs to be revisited, and that person can
Oh, he
reach out.
said to repeat the answer. Sorry, I misread that.
the rebuttable presumption of quantity impairment issue has adequately been raised if the protestant's water right is junior, and it has not been raised if the protestant's water right is senior.
The principle being that if the right comes back into play and the protestant has a senior right, it can't be impaired by virtue of the senior right's priority. So that's kind of the thought process on that. But again, kind of nuanced, and probably need to find better examples for the next time we do this presentation.
Which is why I wanted to end on this slide instead of the thank you slide.
There you go. Why don't you use the mic?
Is this not why the state engineer goes through a general adjudication process to deal with all of this?
So yes and no. The general adjudication process is established to define and establish the water rights. At this time in the course of our, historical statehood and society, the purpose of adjudications is to finish defining the scope and extent of existing rights. We're not quite to a point where we redo adjudications and we revisit areas on a periodic basis to effectuate forfeiture of rights. I am aware that other states might be doing that, but that's not what Utah is doing. So the scope of adjudications is coming up right next.